Let's talk about types of trusts. Depending on the goal in establishing the trust, a grantor basically has two choices, a living trust and a testamentary trust. So let's talk about the living trust first, also called intra vivos trusts. These trusts are created while the grantor is still alive. Typically, the grantor is the trustee and maintains control over the assets. This is a goal of avoiding trustee fees if the grantor remains sits as the trustee. But upon the death of the grantor, the successor trustee who's named in the trust takes over automatically. And the principal of the trust is transferred to the trust beneficiaries. So all of the assets stay in the trust and you avoid probate. There's a trustee that takes over, and then the named beneficiaries will then get whatever assets are in the trust. So most living trusts are revocable, meaning that the grantor can terminate the trust altogether or change the terms of it at any time, as long as the grantor has capacity. Must still be of, well, if they've created the trust, they're already of legal age. So the component is they're of sound mind when they make the changes. Two advantages of living trusts, as indicated, when the grantor dies, the assets flow directly to the beneficiary, avoiding the expense and delay of probate. That's a very big advantage. And number two, if the grantor becomes incompetent, the process of transferring control is safer. It's a safer process, and it's much easier than if the grantor owned all the assets outright. The transfer is much easier that way. There is such a thing as an irrevocable living trust, and this is where grantor gives up all control permanently. Grantor permanently gives up control over the property to the trustee. The grantor executes what's called a trust deed, and legal title to the trust property passes to the named trustee. And the trustee has the duty to administer the property as directed by the grantor for the benefit and interest of the beneficiaries. Now, the grantor can still be living, and usually is, and they are usually the beneficiary until they die. And then the interest and any benefits would then proceed to whoever is named as a beneficiary after the grantor dies. So, revocable trust, grantor can make changes and revoke at any time. Irrevocable trust or living trust permanently gives up control, cannot change it, cannot take back. It's done. It's not revocable anymore. Before I move on to the other types of trusts, I do want to talk about pets briefly. Pets, at least in the state of New York, because I mentioned Leona Hemsley a moment ago, and she was a billionaire, and she left 20 million in a trust to her dog, and there was a big fight over that particular trust. I believe the argument that was made was that she lacked capacity when she made that trust, but it is legal to do. And that Leona Hemsley was a resident of New York, so it was a battle that took place in a New York probate court. But you can provide for pets. Now, in New York State, pets, and I think every state, pets are considered property. So if you were to pass them along in a will as property, they may not go or be treated as you hope they are. You know, you leave your dog to your best friend who says they'll take care of your pet, and then the next thing you know, they get your pet and then they give it away or put it in a shelter. So trusts, New York has made it legal to set up a trust for pets. So owners can actually create a pet trust and make arrangements, but they do have to select somebody who is responsible for their care. But you can allocate funds into this trust for various expenses, right? Vet bills, grooming, food, anything else you thought was necessary. Leona Hemsley thought security was necessary for her dog because her dog was getting death threats and people were claiming that they were going to come and steal the dog. It was a little dog. So there is that provision for pets that New York recognizes. Testamentary trust. Now, this is the trust that's actually created by will or in a will. It goes into effect when the grantor dies. So the grantor's property must actually go through probate first on its way to the trust. So you need court approval for this process. The trust names the trustee, and if there isn't at that point, the court will appoint a trustee. So not having a trust while the grantor is living, but then creating it in an actual will, the process has to go through probate first, so things could be delayed. If the will is deemed invalid, i.e. doesn't meet all the formalities of the state, and is deemed invalid, then the trust that is built within the will is also going to be invalid, and the property, unfortunately, would pass according to intestate laws. So careful in when clients are discussing estate planning on which is the best type of trust to create, one while the person's living or one that's built into a will. I want to say Robin Williams was built into the will. The trust was created during the probate court, and then they had some of those issues, if I'm not mistaken. But nonetheless, they can be created in the will. So the living trust and the testamentary trust are trusts that a grantor actually creates as part of estate planning. The next two trusts we're going to talk about are court created. These aren't related to the passing of property. These are more or less equitable relief that a court awards. We have constructive trusts, we have resulting trusts. So they are discussed in the reading material, so we'll go through them here. And like I said, not a traditional trust, but rather a tool that courts use to resolve property issues. It's actually one that's imposed by a court in the interest of fairness and justice, and think of it as a remedy for unjust enrichment. When one party has been unjustly enriched to the detriment of another person, the court might issue a constructive trust. So where it has been declared that someone wrongfully holds legal title to property, the court will declare a trustee of the property for the parties who are then entitled to the benefits that flow from the property. And I'm going to give an example. Let's say a mother agrees to transfer the deed to her house to her daughter in order to help avoid a drawn-out probate process down the road, or to quote-unquote protect the property from Medicaid or a nursing home. This happens often when people get older. Certainly Medicaid and the state will do, there's a 5-year look-back period on transfer of property. So let's say this has happened 7 years down the road. So in exchange, the daughter agrees to let her mother continue to live there, notwithstanding that she no longer is the legal owner. So mom transfers the house to the daughter, and mother's just going to live there. But after transferring ownership of the home, the daughter decides she wants to sell the home, and or she decides she wants to evict the mother if she does not pay rent to live there. So obviously the relationship's broken down. The mother may challenge the daughter's actions through the invocation of a constructive trust. So to go one step further, meaning she'll go to court and ask the court to put the property in a constructive trust to mother's benefit. But to take that one step further, let's say the sale of the home went through. The daughter may be viewed to have been unfairly benefited from that if she takes the money from the house. So mother may be entitled to what's called restitution, which would include the proceeds from the home, and those proceeds would be placed in a constructive trust for the mother's benefit. So it's court created. What a constructive trust is a court created trust, and so is the next one we're going to talk about. A resulting trust, this arises from the party's conduct, indicating an apparent intention to create a trust. and it's automatically imposed by operation of law. A court will probably have to be involved, but by its appearance, looking at the apparent intentions, it's imposed by law. We could see this arise in, these are the most common areas, situations. One party pays the purchase price for property and causes the title be taken in another's name. The testator or grantor makes an incomplete disposition of trust property, or an express trust fails in whole or in part, resulting in that property being held in a resulting trust. The idea is there's a presumption or inference that the property is being held in trust for the benefit of another. So it results in a trust, or i.e. a resulting trust. Let's look at an example. So using the example of Sally and Bill, who are friends, a resulting trust can arise in these two scenarios. The first one, the gratuitous transfer of property from one person to another. This is where Sally transfers her property to Bill. The title to Sally's property is now in Bill's name, yet Bill did not give Sally any money for the property, so the transfer is referred to as a gratuitous or without payment. Number two, the joint, another example, the joint contribution by two people to the acquisition of property, title to which is in the name of only one of them only. So in the case of Sally and Bill, let's say they both put $25,000 towards the purchase of property. However, the property is only in Bill's name. So looking at these two examples, in both examples above, Sally doesn't have any legal title to the property. In example 1, she transferred the property into Bill's name, and in example 2, the property was only registered in Bill's name. As a result, if Sally and Bill part ways, Sally does not have legal title to the property. If Bill doesn't want to give Sally her interest in the property, Sally can go to court, rely on equitable laws, and equity allows the court to decide what's fair. Since Sally put money toward the property in both examples, the court could recognize her contribution and say that Billy is holding Sally's interest in trust for her. In the first example, the property would result or be transferred back to Sally even though the title is in Bill's name. The court would recognize that Sally paid for the property and Bill paid nothing to acquire the property. In the second example, Sally may be entitled to 50% interest in the property as a result of her $25,000 contribution. So because in both of these examples above, Sally doesn't have legal title, she must rely on a resulting trust to regain her interest in that property. So these are kind of simple examples that illustrate the ideas behind resulting trusts. That is certainly much more complicated in real life, but the point of the resulting trust and the constructive trust is these are court created. They are not created by the grantor, like the testamentary trust and the living trust. Let's talk about the trustee. All right, let's talk about trust administration. This isn't in the reading material, and I'm surprised that it's not because the trustee's job is pretty important. The primary obligation of the trustee is to carry out the terms of the trust. They may exercise any powers expressly granted to them within the trust documents or instrument, and there are any implied powers reasonably necessary to implement the terms of the trust unless that power has been specifically prohibited. Doesn't that sound like agency law, right? That you got express powers and implied powers, and they could be expressly prohibited. This is a agency relationship. And the trustee has fiduciary duties to the beneficiary or beneficiaries. And we have duty of loyalty, they have a duty of loyalty and a duty of care. When we're talking about duty of loyalty, the interests of the beneficiary first, right? No conflicts of interest. The beneficiary's interests are always first. So they have to disclose all relevant information to them. They can't commingle trust assets with personal assets. They can't favor one beneficiary over another, or they can't do business with the trust. Those are some, and we've discussed this already in agency law as general agency duties, but here we are, duty of loyalty relative to a trustee. Duty of care. The trustee must act as a reasonable person who would, when managing the assets of another. So the trustee must act as a reasonable person would when managing the assets of another. And I note this is a higher standard than a trustee acting as a reasonable person when managing their own affairs, considering you managing your own personal affairs versus a client's affairs. You might pay extra particular care with a client. So it's a higher standard. And the trustee, also under the duty of care, must make careful investments, keep accurate records, and collect debts that are owed to the trust. So a trustee, agent of the trust, has fiduciary duties, duty of loyalty, and duty of care. And that is the end of our discussion regarding trusts.